I'd like to introduce our next speaker, Ovide Mercredi, who is a Cree lawyer born in Grand Rapids, Manitoba. And through the years, he's specialized in constitutional law, including as a strategist for the Assembly of Manitoba Chiefs during the Meech Lake Accord discussions. And he's played a leadership role in helping to resolve the Oka crisis in 1990. He's also served as National Chief for the Assembly of First Nations from 1991 to 1997, during which time he led the negotiations on the Charlottetown Accord. Now, he's addressed the United Nations in Geneva and New York and led a human rights delegation to the troubled Mexican state of Chiapas. He's also co-authored In the Rapids, Navigating the Future of First Nations with Mary Ellen Turpel-Lafond. Now, currently, and we're so happy to have him at the university and have the opportunity to collaborate with him, he's working as a senior advisor to the University of Manitoba president. Please join me in welcoming Ovide Mercredi.
Peter, can you hear me? Oh, there's Peter. I recognize many faces here. The political struggle for the recognition of our people's rights is all over this room. And I want to reflect a little bit about what the law is, but also how the law has impacted our people. Because I think we have to get back to the very basics of the relationship. And it has to be with this idea of nationhood, that the indigenous communities or peoples are nations within their own right, and that the formation of the country did not alter their status as a nation of people. And that implies that they have the right of self-determination, which means that they should have the freedom to set up their own political institutions, their own economic institutions, their own educational institutions, and so on, and be free to make laws for their people without interference from any other group in society, or for that matter, from the state itself, from the nation-state called Canada. I will give you a rather personal story about the impact of the law and why Canadian law is offside, and why we cannot base our decisions about the way forward based on Canadian law. Because if something is wrong to begin with, it cannot be corrected. And we can't follow precedent if it's wrong. And if there is any law that is unjust, it should not be followed. These are sort of the fundamental ideas of my people, that if something is wrong, don't do it. If something has been done that is wrong, don't carry on that same wrong. If something needs to be corrected, do it. Correct the wrong. Right? Now, I come from a community called Tsilhqot'in, which means Grand Rapids. And there used to be a rapids there, but that's before hydro showed up. So when hydro built a dam in the heart of our homeland, they also destroyed the rapids. There is no rapids. I guess we should call ourselves There's no more Grand Rapids. My relatives over there understand what I'm saying. So when I became the national chief, I wanted to change the world. Of course, we all want to change the world for the better for our people. And but I was told very quickly by the elders that my role is not about changing anything. It's about explaining who we are to to them. I said, explaining who we are to them. So most of my career has been about that, trying to get Canadians to understand who we are as a people, where we belong as a people, how we see the common vision with the rest of Canada, and where we want to go in the future. So most of my advocacy in the political arena and in the social setting has been about getting back to basics, and that is explaining to the Canadian people that we have rights of self-determination as nations of people. We're not just citizens of the country, that our ancestors made treaties with the Crown, and that these treaties are not made with subjects of the Crown, but of independent nations of people. And we want to maintain that identity. Okay. So I guess growing up in Grand Rapids, I learned very quickly the impact of law, how law can be so wrong in its application. When, as a young boy, I discovered that my mother lost her status as an Indian person because of the Indian Act. So when my mother lost her status as an Indian person under the Indian Act, the law at that time was that you could not live on the reserve anymore. And these were not laws that were made by the Cree people. These are laws that were made by a white parliament. But the reality is this, that she lost her right to live on her land. And she had no choice but to move across the river where my father lived, was non-status, Cree, French mixture. And so we grew up off the reserve. So I never grew up on the reserve because of the Indian Act, see? So there's something, that should say something to you, like what right does a foreigner have to define who I am? And what right does that foreigner have in terms of, by defining who I am, disconnecting me from my society and destroying that link to my rights as a treaty Indian? Of course, they don't have that right, but they took it upon themselves anyway, which is why I said earlier that if a law is fundamentally wrong, you have no business following it. Right? And it's wrong to say to an Indian woman that you are no longer an Indian. That is wrong. And the same thing when you contrast that same Indian Act that made white women into Indians, I have to say to you, many times I've thought about that, and I've said to myself, how powerful are these people that they can turn a white person into an Indian? How powerful are they that they can do this? They can take the right away from my mother, but they can give it to somebody else who marries an Indian on the reserve. This is the Indian Act. This is the law that is the most oppressive form of legislation in this country. And this is the law that defines who has a treaty right in this country. Now, when I would think that my mother has a greater right to benefit from a treaty right from Mississippi Cree Nation than the woman who married Indian men from the white woman who married Indian men from my community, who became Indians by virtue of the Indian Act. And I say that respectfully, not in a racist manner. But what I want to draw to your attention is this. So by losing our rights to live on the reserve, she also lost her right to fish, hunt, and trap, which were guaranteed by the treaty. And she would have also lost her right, whatever those rights were in terms of the right to education, the right to health, and so on, that these rights would have been terminated when she married my father. I say that in my language, we say mamaskat, which simply means, that's baffling. Yeah, it's really baffling that that my mother would be discriminated in that manner by the Canadian government. And the treaty itself should not be defined by federal law. The treaty was nation to nation, government to government. The only way that it can be altered is by the two parties getting together to talk about it again. There's no other way of doing it. Any other way is wrong. Any other way is unjust. And they might come up with nice phrases like the duty to consult and accommodate. And they might come up with some tests on when the Crown can interfere with the treaty right. But that's also wrong. They have no right to assume that power on treaty interpretation. Treaty interpretation should be based on the parties that made the treaty sitting across the table from each other, talking about what the treaty means, and if they disagree, to try to come to understanding what it ought to mean for the future. But it should not be left to one party and their legal system to define what those rights mean. That is wrong. But that is what we have in this country. And the judges, the lawyers, they all make this vow allegiance to the legal system. They're obliged to work within it. But those of us who have been championing the cause of our people for so many years now know that we don't belong there, and that we cannot define our rights in their legal system. Because if we do, we will definitely lose. Because there is no way on this earth that anybody that is a Canadian that's going to make a decision that will impair the sovereignty of this country, that will give us the absolute rights that we deserve, because that will impair their territorial integrity and their sovereignty, and that will never happen. And the only way that there can be treaty justice, the only model that I can think of, because it's an actual model, is the one involving the Maori people in New Zealand, called the Treaty of Waitangi, where they established something called the Waitangi Tribunal, where the state appoints 3 people, and the Maori nation appoints 3 people, and between the 6 of them, they appoint a chairperson. And then when issues of treaty interpretation have to be dealt with, they go to this tribunal, and the hearings are conducted in English and in the Maori language. That's what we need here in this country. Not the provincial court or the Queen's Bench Court or the Court of Appeal or the Supreme Court of Canada. That's the wrong vehicle. That's the vehicle that will narrow the rights of our people, because it is impossible and virtually unlikely that anyone sitting in the Supreme Court of Canada is going to acknowledge our rights as we see them as Aboriginal people. It will not happen. So let's come to that realization and start talking about alternative ways of defining treaty rights. If we need a mechanism, then we should be honest. We should be very honest about it, that the current legal system is not the mechanism, period. Now, as a child, I hunted, I fished with my father. My mother was the hunter, so I hunted with her. And so you'll be surprised to know that I became a juvenile delinquent, because one day I was hunting, and I had these 5 upland game birds because I was a pretty good shot. And I was stopped by a conservation officer and was asked if I had been hunting. And of course, one of the things that Indian people are required to do when they're asked the question is to be honest. My game was in the trunk of a car. I'm already a teenager. And I open the trunk, and he sees that I have 5 upland game birds, and he charges me for hunting out of season. Now, if I had the treaty right to hunt, if my mother would not have lost it, I would have used the defense that I have a treaty right to hunt. But by virtue of the fact that my mother lost her status under the Indian Act and therefore our rights under treaty, all our children lost their rights. So in other words, I had no treaty rights growing up. I didn't know that at the time. And that happened only because the federal government decided in 1919 to pass something called the Migratory Birds Convention Act. And this was an international treaty that was made into domestic law. And many of our people were taken to court for hunting out of season because of that piece of legislation. And this, too, was a violation of the treaty. Like, look at it this way. You, as a non-native person, you look at it this way. I pass a law as a Cree person. And in my law, I say to you, you don't have the treaty right to the land you're sitting on. Would you accept that law? I don't think so. So why should then I accept your law that says I cannot hunt out of season when I know that the treaty is there that says I can? So that is the fundamental issue. That's what I'm talking about. We have to get back to basics here about nation to nation and the right of self-determination and the sovereignty of my people, which was not impaired, which was not altered by the treaty, but was enhanced by the treaty. Our right of self-determination, our sovereignty was enhanced by the treaty. And if you look at the right of a livelihood, the culture of the people, their language, their spirituality, the treaty did not extinguish our sovereignty of our people, our sovereignty of our traditional lands and resources. The treaty did not take any of that away. What the treaty did was it affirmed those rights. It didn't take them away. And when it came to things like the environment, it's the treaties that are the strongest instrument right now for the protection of the environment. Because the right to hunt, to fish, and trap is about the habitat of the fish and the animals we rely on. So it's really a way of saying to the forestry company, we have a treaty right to the protection of the environment, because our right to that livelihood is guaranteed by the treaty, and that livelihood will cease to exist if the environment is destroyed. I think you mentioned something about this idea that we need to look at the nature and scope of treaties. I agree with that. But I disagree that we need to do it in the courts. And in our political discourse as leaders in the Assembly of First Nations and all the political organizations across the country, what we despise the most is something called 9124, which is part of the British North America Act, that says that the white man has the power to make laws for you and your lands. We despise that law beyond reason. Because I don't know where Canada or John A. MacDonald or any of these people like Laurier, where they get off their high horse. What right did they have to say when they went to Britain to make the British North America Act that we want control of the Indians and Indian lands, and to do that without talking to our people? Of course they have no right. But they did it anyway. But they had an intention. And their intention was to create a country coast to coast. And that the Indians would be a problem, in their view. So they had to manage that problem somehow. And what better way to do it than through this idea of making laws that would be imposed on the Indians and the law like the Indian Act. Do I sound happy? Give me a reason to be happy. We have a celebration for Canada coming up in 2 years in 2017, and we're not going to be that happy. I assure you that the Aboriginal people in this country will not be celebrating with the rest of the country. And for a very good reason. So when I came to law school, and I used to sit in those desks here, and it's probably my first time on this side, so that's what it looks like. I just want to look at a watch. I read this case about treaties, a hunting case, and I come from this background. Let me explain it this way first, because I'm not looking at it as a Canadian. I'm not looking at it from that perspective at all. Ayu anisnina nahe ininu. I am a Cree human being, nahe ininu, and the Anishinaabe have their word for themselves, the people. We have a word too, as a Cree, called Anishinaabe, the people. And the Dene have their word as well. And what is it for the people? Dene. So that's their word. See? And the Lakota people, is there any Lakotas in here? Well, they have a word for themselves too. And it usually means the people. Right? And if we wanted to be more specific as to where you came from, you would say, Misipais Tigo Inunina. You would say, I am a Cree, Indian, or Native, whatever, from Grand Rapids. Right? And so I came to law school with that understanding, because I grew up in a community that was isolated, and we had names for white people too, nice names. So, like, for just generally white people, we say Emstuguswak. Emstuguswak. And then we had a name for the Catholics. Pakoyas. Pakoyas. I'm not sure why they have a different name, but because they have a different identity, I guess. And we recognize that they were not English and that they themselves had a different culture. So we had two names for non-Aboriginal people. And outside of that, I had any contact with the rest of the world, so I had no names for, say, black people. Never saw a black person until I was probably 20 years old when they came to work in Grand Rapids. So my world was where the Crees were in control, where the language of commerce and the language of religion and the language of day-to-day life was Cree. That's how I grew up. And for me, we were the majority. We were not the minority. We were the majority. And if people came to us to talk to us, well, if they were going to stay with us any length of time, they'd have to speak Cree, like the priests and the ministers and the people that had stores, like the merchants. They had to speak our language because that's where we were in control of our society. And the only people that wouldn't speak our language were politicians. I wonder why that is. And also the RCMP and the nurses and the doctors that showed up intermittently and for short periods of time. But they didn't live in the community, so they didn't really need to speak the language. So I come to law school from that understanding, that I come from a different nation of people, that I have my language, we have our society, and that we have our own livelihood. And then I read this case about the treaty that says that the federal government, that the federal legislation is paramount over the treaties. that a federal law is paramount on the treaty. And I question myself, well, what right does Canada have to impose their law to define a treaty right? How would they feel if we define that treaty right using our laws, our traditional laws? Would they accept that? And then I move on with my life. I get involved in these constitutional discussions where Meech Lake is happening, and the Aboriginal people, the Inuit, the Métis, and the First Nations people, they all come together to oppose Meech Lake because it's a violation of the history of this country. It's a violation of their place in this country. And it's an ignorant statement of what this country is. The idea of the two founding nations is what we oppose. And so we set about to defeat the Meech Lake Accord. And the best explanation as to why we did that came from the words of John Amagalik, who was an Inuit leader. And he was interviewed by the press, and his comment was, if Quebec is a distinct society, what are we, chopped liver? I mean, there's no better way of expressing your opinion about what foreigners are doing on your homeland, and how they're dismissing your place in your homeland and proceeding as if only two nations exist in this country, the French and the English. That's why we fought against the Meech Lake Accord. Not because we're mean-spirited people. We're trying to protect our identity. Now, then a time came when Trudeau wanted to patriate the Constitution, and he started this process of discussions for constitutional discussions. And we got involved in that in the 1980s, right up to 1992. And the first part of that process was to resist the patriation of the Constitution. And many of our people went to London to oppose the patriation being transferred, the documents being transferred to Canada. Not because we didn't think that Canada should be able to amend their own constitution, but we didn't trust them that they would do it in a way that would be inclusive of our people. So we wanted to make sure that our treaties would be respected and that our Aboriginal rights would be protected. And that's why we ended up with what's called Section 35 in the Constitution. That came about not because of the goodwill of the country or the government or the leaders. That came about because of our political resistance to the patriation of the Constitution. And then when Section 35 was put into place, there was a partner provision called Section 37 that required the Prime Minister of the day to convene meetings with the Aboriginal leaders with the explicit purpose of identifying and defining rights to be included in the Constitution. So we had these rounds of constitutional discussions that lasted for a whole decade. And the debate amongst ourselves, internally in our own political structures, was one camp saying we have a full box of rights under Section 35, and another camp of our people saying, no, that is empty. That's an empty box of rights. It means nothing. And so the discourse was never about going to the court to define what that box is, never going to the court to fill that box up. The discourse was about we have to have a dialogue with the governments. We have to move forward in terms of the constitutional protection of our rights. And that's where Charlottetown comes in. The discussions about Charlottetown Accord was about how important it was for us to have a political understanding on what that process was going to be going forward into the future. So Charlottetown, when you have time, you can do this research yourself, had a provision for treaty implementation. And it was a provision that would have involved the provinces to the extent of their jurisdiction and only upon the request of the First Nations And the reason why we put that provision in that language is because we believe that the bilateral relationship between us on treaties is between our people and the government of Canada, the Crown in right of the government of Canada, not the provinces. And this is what you were talking about, how the Supreme Court has now altered that relationship. And I don't know where they get the power to do that, but I guess they can do whatever they like and don't have to follow it. And our people don't have to abide by it. And our people will not abide by it. That's the political reality of this country. Right? And then Charlottetown had a provision also for the recognition of a distinct order of government for Aboriginal people, a third order of government, not a third level, a third order of government. And that this would be justiciable within 3 years of the proclamation of the new law, which of course never happened because the referendum, it was defeated in the referendum. So Charlottetown never became law in this country. But had Charlottetown become law in this country, none of us sitting here would be here today, because our right of our third order government would be recognized in the Constitution of this country. We would not be negotiating whether we have the right to govern ourselves or whether the Indian Act should still be the source of our government within Canadian law. No, Charlottetown would have gotten rid of the Indian Act. And the process in terms of the implementation of the inherent right of our peoples to govern themselves was not about whether Canada should delegate the powers to us. No, it wasn't about delegation of powers. The assumption was that we had these powers to begin with. What the negotiation would have been about is how the jurisdictions would coexist. And I remember a discussion that we had there about the idea of paramountcy. Like the example that some of the people gave was if a First Nation government made laws on the environment and it conflicted with a provincial law on the environment or a federal law on the environment, which law would prevail? So I have 5 minutes. So I said, well, we'll create our own peace, order, and good government provision. And in the meantime, we'll use the Supreme Court directly until we have our own Supreme Court as Indian governments. And we also talked about this idea of the Charter of Rights and Freedoms, because all the white politicians didn't trust the Indian leaders, and they thought that they were better at protecting women's rights than the rest of us. So they wanted to make sure that the Charter applied to us. And we weren't opposed to women's rights. And we were not about to be told by parliamentarians who had less women in their parliament than we had Indian chiefs how to respect women's rights. So we had these debates with the white politicians, and we came with this understanding that in the interim, we will apply the Charter of Rights and Freedoms, but there will be an allowance, and you'll see that in Charlottetown, for all the First Nations people to have the capacity to create their own Charter of Rights to apply to their governments. And the reason why we fought so hard for that is because we didn't see the Charter of Rights and Freedoms that's there as being adequate to protect our society. And because the Charter of Rights and Freedoms that you have is really about individual rights and civil rights, the right to counsel, the right to association, all these things. We were more interested in the idea of the right to health, the right to a healthy environment, the more collective rights that belong to people as opposed to the right of the individual. Not that we were opposed to individual rights either. And I recall, and I'll end this comment with a discussion that I had once with Trudeau, and it highlights what I'm trying to convey to you about nation to nation, government to government, collective rights versus the rights of a citizen. Trudeau asked me this question after he stood up and talked for a bit. Chief Mercredi, why do you think your people are better off with individual rights, with collective rights, when I believe that the individual rights will help your people more. Something to that effect. It's been a while, so I can't really recite it word for word. But that was the essence of it. And I said to Mr. Trudeau, because he was the Prime Minister then, I'll talk to you as I would talk to my elder. I said, the reason why we are advocating the collective rights of our people is because we want what you have. A collective right to rule your people. A collective right to govern your land and your resources. A collective right to your own institutions of government and adjudication. A collective right to language, and so on. And then I said to him, and if my people were to benefit from individual rights as you claim they would, why is it that they're living in severe conditions of poverty in this country? If individual rights was the solution, our people would not have any poverty in their lives. So that's why it's important for Canadians to appreciate who we are as a people, where we come from, and why we speak the way we do. And that the law is not the place to define that relationship. That it has to be nation to nation, government to government. And the problem with this country, though, is that the political will has never been there to engage our leaders in that way, other than how close we came to some consensus with Charlottetown Accord. And when we were dealing with Charlottetown, for example, on the right of self-government, or the inherent right of self-government, I was getting sort of advice from different premiers. One camp saying, you better define the right, otherwise, in the future, if it's not listed, the right won't exist. So they wanted us to create a third division of powers, federal, provincial, and Aboriginal powers of government. And but my position was, no, we don't want to do that, because we don't want to restrict the evolution of our government to just a list of powers that you're prepared to give us now or acknowledge now. Right? So I insisted on a broader definition of what the inherent right would mean. And it would mean sovereignty of our people, our territories, our lands, our resources, our culture, our language. It was just a general description. I was being consistent with two societies. One was being consistent with our own society of being open-minded, open-ended in terms of not defining everything specifically, but also the British tradition, because Britain has no constitution, and yet it's probably one of the more democratic societies in the world. And what we saw in terms of the evolution of our government was that each nation would define itself, and each nation would define its own citizenship, that each nation would make the laws for their citizens, and each nation would have authority over their lands and their resources, and each nation would store their languages, and that each nation over a period of 25 years, 50 years, or 100 years would become stronger over time, and that we were using the Constitution, Section 35, as a resting place, not a permanent place, the place to rest for a while, and that we would transform our people, we would transition our people from assimilation, from integration to self-determination. That was the idea of Charlottetown.
Thank you very much, Ovide. We have time for a couple of brief questions. If we have a couple of students that have mics, we have a few roaming mics. If you put up your hand, just introduce yourself briefly, and then we should have time for probably 2 quick questions or so.
Yes, I'm Leo Nice, and I teach at University College of the North. At one time in my life, I was a practitioner of law, but I'm recovering. Anyway, the point was made by Robert about the abolition of interjurisdictional immunity. And I guess my question, when I read the Tsilhqot'in decision, of course, that sprang out at me right away that, oh, the court is moving away from this idea of interjurisdictional immunity. But I guess this may be pedantic, but I'm not sure that the interjurisdictional immunity is being abolished as between federal and provincial governments, but certainly I agree with your contention that for purposes of the Crown dealing with Aboriginal nations, it has been abolished. And I guess where this leads up to is, and again this touches on what Ovid had said also, that I think that the Supreme Court is not really comfortable making decisions that are inherently political, and that essentially the purpose for their statement in Tsilhqot'in, therefore, is to put this matter back in the hands of the political authorities as opposed to the legal authorities. So I guess that's my question. Is that seem like a reasonable interpretation of the Tsilhqot'in decision?
So I'm not quite sure if this is on, but let me take I'll try to do a quick answer to that, which is, I think the whole thrust of the Supreme Court of Canada case law since Haida has actually been, in a way, as much as courts can do it, wishing that Ovid's vision of the world was true, which is that they, and actually I don't necessarily disagree with this. In fact, I definitely don't disagree with this. I mean, the Supreme Court of Canada's vision of how this should all work is, and I call it, they're like people playing volleyball trying to keep the ball in the air. Like, they desperately do not want to make substantive decisions. They hate deciding cases like Tsilhqot'in. Okay, because they know there's no upside for them. They know that if they decide that the rights are gone, they're going to be condemned and hated as racists and as, you know, making terrible decisions. If they make a finding that there's a vast swath of Aboriginal title, they're going to be viewed as historical revisionists who are undermining the economy of Canada. They want the problem solved politically or morally or some way that doesn't involve them making a decision, if at all possible. So I actually think that when you look at the overall thrust of all of the cases where they can do it, it's to push everything into the, and don't throw anything at me when I say this, but into the consultation framework. And they use consultation as their legal substitute for negotiated engagement between, and I think they actually view it as between nations. Like, they, in the ideal world, and I actually agree with them, that the only just solutions are going to arrive through consensual negotiation. I just happen to think that there's not much hope of the current non-Aboriginal governments doing anything that they don't actually have to do. You know, and that's just reflective of their politics and I think of a deeper problem, which I was trying to allude to in my talks, which is that most ordinary Canadians are profoundly in the darkness about the content of treaties, and that makes it very hard in a democracy to get the government to do anything that doesn't match up with that. So, I mean, I think there's a huge process of education that has to happen. I don't know, Ovide, do you want to add anything?
Just working. Thank you. There's a well-known mixed metaphor in Treaty 1 territory that's usually attributed to the late Chief David Crushane. And it goes, now is the time to grab the bull by the tail and look him squarely in the eye. I want to congratulate the organizers on the very subtle hints they've given us with the picture they have in the front. They've invited us to be critical, and that's what I'll be. And my question is, what do you think of this? You notice that the perspective is from the behind part of a horse. So, in that spirit, I offer the following comment and ask for your opinion. It is about what is being discussed here, which is the legal witchcraft by which Canada took over the lands of the Indigenous people. My first point has to do with the idea of the Aboriginal perspective, which has been discussed here. It is not what Aboriginal people will say today or tomorrow or what people say. The fundamental purpose of the Aboriginal perspective, as I see it from the court, is to gloss over the fact that the common law cannot, has not, and never can enforce the laws of First Nations. What the courts do is to pick out, just as they do with custom and have done traditionally, is to pick bits and pieces of the laws and the customs and the society of the Aboriginal peoples, and then they, that is the judges, decide what aspects will be enforceable as law. And that is very, very well established law. Now, my other point is this about the Aboriginal perspective. It's the real issue is, I think, captured in one thing that Ovide mentioned, which is the idea of the nation and negotiating how to live happily together. And the concept I propose is that of conflicting public interests. And the court takes a different view. But to me, a government in Canada is said to have the authority to decide, to identify and to promote through legislation the public interest. Same thing for each nation, as Ovide would have it. That it identifies what are its preferred interests. So reconciliation, as it is talked about, makes no sense in the abstract. It makes sense only in the sense that there are conflicting public interests. It's not reconciling in a sociological or poetic sense. It's reconciling conflicting public interests. And the nearest that I know of in the case law that has identified that is the opening statement by Mr. Justice Bainey in the Mikisew Cree case. Now, my final comment is on the interjurisdictional immunity thing. And I'm glad that our speaker today fought, as I gather from what you said, fought for it. What is lamentable, there are two things. One is that this weakens the traditional policy that dates back to imperial British policy of protecting. There's a basic compact at the beginning whereby allegiance is traded for protection. And in order to do that, then the policy is to have the government as far away as possible from the local interests that clash most immediately with the interests of the local First Nations. Keep it away. And that's the idea behind 9124. So these two decisions seriously erode that. And the lamentable thing is that it erodes it without any serious analysis. The kind of analysis that one would expect of the Supreme Court of Canada when making an extremely important, fundamental policy decision. I agree. I think it's open to suggest that the court can be accused of being a policy second-guesser in some of these things. You look at these two decisions and you will find the court saying, Delgamuukw establishes. Really? It's all over there. So what is the authority for establishing the law based on Delgamuukw? And then, on the point of interjurisdictional immunity, the court says in both cases, they ignore what Delgamuukw said. Because Delgamuukw, if I remember correctly, actually discussed and supported interjurisdictional immunity. But when it suits the court, without serious analysis, to jettison it without authority, then the court overlooks its previous view that Delgamuukw establishes anything. So, sorry to go on too long, but those are my observations, and I'd be interested if you have anything to offer us. And again, thank you to the organizers for inviting a critical perspective.
There's quite a bit there. I'll just say one thing, and it's just on the the issue of abolishing interjurisdictional immunity. It ties back to something Ovide talked about. What I thought was, there's a big trend in the law. I mean, Aboriginal law lives in the bigger ocean of law, and there is a bigger trend in law that the court in a whole bunch of areas has been cutting back on interjurisdictional immunity, for better or for worse. What I personally found quite shocking, and when anybody disagrees with me, I find it shocking. I mean, how could it be? Is that there's a very interesting quirk, and I think it's in Section 37. You'll probably correct me if I'm wrong on this. But there's this funny thing that happened in the Constitution when the constitutional conventions were held pursuant to Section 37 in the 1980s and didn't really produce much by way of fruition. There was an amendment made, I think it was to Section 37. I think it's now Section 37.1 of the Constitution Act 1982, which actually says that there will be no amendment to Section 9124 without a conference with, and I forget the exact phrase, but essentially that there'll be a conference convened with with Aboriginal leaders to discuss the matters. I'm paraphrasing slightly. And considering that Section 9124 really had two bits. There's the bad bit, which was just described very nicely, which is the bit that says we have the power to do unto you what we wish to do. The good bit of Section 9124 was, and at least the province can't. And in effect, what they've done now is they've taken away the good bit and left us with the bad bit, which is not a happy story. And what I find surprising is that they did it without reference to the provision of section, and I think it's either 35.1 or 37.1, which clearly contemplates that there'll be a process of negotiation with Aboriginal leadership before there's change to 9124. So, but I do, the problem is the old story about Justice Pigeon. He tells a story about one time struggling with a case, and he's sitting in his office. Actually, he said he was standing in his office, looking out the Ottawa River, going, "What is the law? What is the law?" And suddenly it came to him. It's whatever I say it is. And to some extent, that's what the Supreme Court of Canada has done to us.
And I just want to offer a comment as well, and that's this. If the inherent right of our people was recognized in Canada, right, even in the absence of any specific provision in the Constitution, if it was politically recognized and implemented, and the governments did not interfere with us, we would not need any protection from the province, because we would have the authority to make the legislation that we need. We would have the mandate that we would need to rule our land, our resources, and our people. So we would be equal to them. We would need no protection. And when it came to 9124, it was wrong to begin with for them to assume power of our people like that. It was a mistake, and they should admit it, and then move away from it, and stop using 9124 as a way of suppressing our people through legislation. And because it was through the Indian Act that they allowed the provincial laws to sneak in, and progressively over the past decades, they've been more flexible, giving greater authority to provinces to apply laws of general application to our people, in the absence of our inherent right to govern ourselves, right? So they've been able to do that because of 9124. So to me, getting rid of 9124 is a must to getting to the authority that we need to govern ourselves. And in fact, I'll quote one more leader, James Gosnell from British Columbia, when we were having the constitutional discussions in the 1990s, and the Métis Nation was trying to get into 9124. And James Gosnell said, we don't want to be in 9124. We want to get out of 9124 because we want our self-determination. So that's the contrast, you see. I think my own sense of the future is that there has to be a return to the constitutional table. That the promise for the identification and definition of rights for inclusion in the Constitution is a broken promise. And that when Trudeau failed and Brown Mulroney failed, Chrétien said, we have constitutional fatigue. We don't want any more constitutional discussions. Well, Chrétien, I don't know what kind of a flu that is, constitutional fatigue, but I don't have it. And I want to get back to it, right? Because to me, that's where the nation-to-nation discussion would happen. And that's where the Turo Wampum would be given life. This idea that we're in the same river, that we're separate vessels, that we can make these bridges on those two vessels, but we have to have a common vision for this country. And that's what Charlottetown tried to do, and that's what constitutional discussions will do. We have to get back to it. And then for the legal scholars who are here, my advice to you is come up with some creative ideas of tribunals for the adjudication of treaty and Aboriginal rights instead of us having to use the colonizers' legal system.
Thank you very much. We have some gifts to offer to our presenters from the students. And again, thank you very much to both our presenters.